Hi, everyone. Welcome to the Data Chronicle podcast. I am your host, Scott Loughlin, and co-chair of the privacy and cybersecurity practice here at Hogan Lovells. Today, we are discussing international data transfers and the European Commission's finding that the data privacy framework is, quote unquote, adequate. On a prior episode, we discussed the adequacy decision from an EU exporter perspective, and in particular, how companies based in or operating in the EU may leverage the decision to export data to the United States, and for how long they may do that. Today, we are going to discuss the framework from a different perspective, and in particular, focused on U.S. importers. In particular, how can U.S. importers and U.S. companies leverage the framework to lawfully receive EU personal data in the United States? We'll get into those issues with three of my guests, Bret Cohen, Julian, Flamant, and Natalie, Perez, all data protection lawyers here in the United States working with companies to transfer data around the world. Welcome. Bret, maybe I'm going to ask you to start us off and maybe level set with the audience. What is the DPFF? It's called the Data Privacy Framework, and why is it currently in the news?
So the data privacy framework, let's call it Safe Harbor 3.0. It is the agreement between Europe and the United States to enable companies to register for compliance with the framework that will enable the transfers of GDPR covered information to those US-based companies. So it really is the third iteration of Safe Harbor, which was the program as it was called until it was invalidated by the Schrems 1 opinion back in 2015. We regrouped, we renegotiated it and called it Privacy Shield. That too was challenged and overturned by the European Court of Justice and was subject to additional negotiations between the European Commission and the US Department of Commerce, who, after enacting a few additional protections in place from related to US government surveillance, have reborn it from the ashes again, and it is now called the Data Privacy Framework, and it sort of takes the place of Safe Harbor and Privacy Shield.
Okay, so if I'm getting it right, here is our third time at trying to address a problem that continues. How can EU-based companies, under their laws, transfer data to the United States consistent with US laws? From your perspective, is this a political issue? Is this an issue with a clash of the European law and US laws? Kind of what is at the heart of the reason why we are now doing this for a third time?
The reason we're doing this for a third time is to try and make sure there's a durable framework that complies with European law. So the first two frameworks were struck down on the basis, not that the US didn't have appropriate commercial protections in place under Safe Harbor or Privacy Shield to protect personal information, but because US national security surveillance laws permitted a certain bulk collection of information without particularized warrants or allowed for sufficient redress according to the Court of Justice of Europe, that their existing laws did not sufficiently protect European personal information. And so what this third attempt is trying to do is trying to add additional mechanisms in place, additional protections with respect to the concerns of the Court of Justice in Europe to try and make sure that once the data is in the United States, that the only circumstances under which it can be accessed by US law enforcement are consistent with European law as found by the Court of Justice. And the reason why this has got a little tricky is the Court of Justice in Europe is like the Supreme Court of interpreting the European Charter of Fundamental Rights. And they said European data can't go to the US consistent with these US laws in place. And so it required sort of a fundamental change to how US law enforcement would access data under its national security laws in order to meet this standard set forth by this high court in Europe.
And Scott, if I could just add on to that, because you did ask about the impact of not having this mechanism in place. The International Association of Privacy Professionals actually did some research on this. They put a survey out in 2021 following, within the months or the year following the invalidation of the Privacy Shield. And what they found was that 10% of respondents reported that they had either stopped transferring data from the EU to the US. Obviously, there were still mechanisms in place that they could use, but they determined that without the Privacy Shield, for whatever reason, it didn't make sense to do it. And so that could have either been stopping to provide their products and services in Europe or localizing data of their European customers within Europe or some other impact on their business. And so that was conducted in 2021. I suspect that a year later in 2022, the impact would have been even greater, but that's speculation.
That's helpful, Julian. And maybe I'd ask you to chime in on this. One of the things that we discussed on a prior episode with Eduardo Eustron and Julie Schwartz from our UK and EU offices, what is the baseline that's set out in the GDPR? In other words, is it unlawful under the GDPR for EU-based data to be transferred to the United States? And if it's unlawful, why is that the case?
Sure. So the GDPR, right, which came into force in 2018, kind of picked up on this baseline prohibition that existed in the directive, so the previous data protection law in Europe, which is a baseline prohibition on transfers of personal data about Europeans to third countries. And so really what that does is the law restricts transfers of covered data to other jurisdictions unless there is some kind of mechanism in place. So there is that baseline restriction. And then there are kind of a whole bunch of ways that data can be exported. One, notably, is through an adequacy mechanism where the European Commission finds that the laws in the other jurisdiction, so the jurisdiction receiving the data, provide a sufficient or an adequate, or as it's been kind of outlined by the Court of Justice, an essentially equivalent framework for protecting personal data. So that would kind of mirror what is provided under the GDPR and under European Union law. In addition to that adequacy mechanism, or that, that possibility for there to be an adequacy finding by the European Commission, companies can implement appropriate safeguards. So good examples of those are the standard contractual clauses that the European Commission has adopted, or the binding corporate rules that a group of entities could enter into. These are appropriate safeguards. And then, of course, there are also derogations. So these, should be used kind of less frequently for specific circumstances, but those would be, for example, where the data subject in Europe provides consent for that transfer. And so the whole game here is to figure out how to circumvent, or maybe how to transfer data that's collected in Europe to another jurisdiction without running afoul of the GDPR. I mentioned the adequacy decision. I think there are 14 adequacy decisions currently, or maybe this is the 15th for the data privacy framework. So basically that's what's being accomplished here with the data privacy framework. The reason this is so interesting is because the adequacy determinations that the Commission has issued outside of the US context, so for example, for Argentina or Japan, New Zealand, or hotspots like Jersey or Guernsey, are related to the framework for data protection that the company has put forward. So the law is applicable to all companies operating in that jurisdiction. The data privacy framework is a little bit different because it is a full adequacy determination. So it has the force that adequacy determinations have, and it comes from the European Commission, but it applies only to this specific mechanism, which is this negotiated agreement between the US and EU governments that companies in the US can self-certify to.
For all of you who got excited there, that's the Isle of Jersey, not New Jersey. New Jersey is not adequate.
On that point, Bret, New Jersey, you said, is not adequate. Is the United States adequate?
As of today, right, because we have the adequacy determination from the European Commission, companies who are signed up to the data privacy framework, and I believe all of the existing Privacy Shield certified companies were grandfathered over. transfers to them are now continue to be adequate.
That's right. And I actually have something to add on that, because this is like the privacy nerds' favorite topic, whether California, now that they have the CCPA, whether it could be found that companies operating in California and applying CCPA protections to data transferred from Europe into California could be considered adequate. I think there are some non-data protection law related questions to address there, like if California can enter into a treaty or an agreement with a foreign nation. But I think the interesting piece to consider, it follows from what I said about the data privacy framework being a specific transfer mechanism that's been found to be adequate. So what the data privacy framework does is add a handful of principles that track GDPR, that companies are self-certifying that they adhere to when they receive European data. Well, so those principles are part and parcel of the privacy laws that are developing now all over the world, including in the US states. And so it would be interesting to figure out if either CCPA or one of the other laws, if a company can show that it complies with those laws and would apply it to the data it receives from Europe, whether eventually the commission could do a new adequacy finding on that basis.
Natalie, I'd love for your take on this, because as I understand how this all has come together, is that starting from a baseline, it is unlawful under the GDPR to transfer data to a third country. There are a number of exceptions to that, including whether the third country is as determined to be adequate, or you put in some additional mechanism, whether that be the data privacy framework, the privacy shield, any of the other predecessors that we've had to this. The BCR, as I understand, is kind of another option, SCCs, and then the derogations that Julian. So there's a whole long list of exceptions. Baseline can't do it. Then let's say, can we do it through one of these exceptions? How have you seen in your practice companies try to respond to allow for the transfers of data after the privacy shield was invalidated?
So the most common mechanism I've seen clients use are the standard contractual clauses that you mentioned. So these would be clauses that were actually drafted by European regulators that companies looking to transfer European data subjects to non-adequate countries just need to include in agreements with recipients. And one common thread you'll see is that all of these mechanisms really try to apply the principles that Julian referenced to the recipient of the data. So in the case with standard contractual clauses, you'll see a lot of those principles just being applied to the recipient. In the case of data privacy framework, you'll see that participating companies need to certify that they are complying with these principles. And if you take a step back, the intent of European regulators is really just to make sure that any recipient of Europeans' data is actually providing the same rights and subject to the same restrictions on that use of data that anyone in Europe would be. Just to add a finer point on that, the challenge and why us privacy nerds and potentially our clients are very excited about the data privacy framework is that transfers to the U.S. based on standard contractual clauses have been under the microscope, and their validity is still in question because having the contractual clauses in place is actually not enough. They need to be accompanied by something called a transfer impact assessment, whereby the risks associated with the transfer have to be outweighed by the benefits. It's a gross oversimplification, but I think okay for our purposes. But the real challenge is that transfers to the U.S. are generally considered to be very risky because of this view that intelligence agencies can access data without precise warrants, as Bret mentioned at the start of the call. And so what this data privacy framework and kind of the two-tier mechanism for reviewing intelligence agency related access does is it kind of reduces that risk to a level that hopefully is acceptable to Europeans.
There's a lot baked in here, a lot of protections and a lot of controls and limitations that are imposed on U.S. national security surveillance on the basis of this. There's additional layers of review that need to go into place before certain types of collection is authorized within the intelligence community. There's new multiple layers of internal review courts. There's a new data protection review court, and the Civil Liberties Protection Office of the Director of National Intelligence has to validate surveillance activities for legitimate national security objectives. These are things that other governments around the world are not doing, and many are being found adequate, right? There's adequacy determinations recently in South Korea and in Japan, in the UK, and there's talks around the world. So there's a real hope here that these additional protections will demonstrate that there really is more of a concern in the US for the issues that were pointed out by the Court of Justice in the Schrems 2 case, and that this will be a durable mechanism for going forward.
Yeah, that's a good point, Bret. And Natalie, I think, you made a point that I would love to amplify, right, is around those principles that cut across all of the various different types of approved data transfer mechanisms, whether those are principles that are inherent in other countries' quote unquote adequate laws, or they are principles that are inherent in BCR, approved BCRs or SCCs, or what was previously within the Shield. These principles are not new. Really, they are a distillation in multiple different ways to try to make up for the fact that presumably in the minds of the European Commission, the United States does not have a comprehensive law that embodies those same principles.
That's right. They're not new. And in fact, they'll be familiar to any company that participated in the Privacy Shield, because by the Department of Commerce's own admission are substantively the same. And as we were kind of alluding to before, these principles are found in the omnibus state privacy laws that have been passed at the state level. Not only the CCPA, but also the state privacy laws passed and recently effective in Virginia, Connecticut, and Colorado. And probably bears mentioning what these principles are so that the listeners out there can know whether they're actually adhering to them. So just at a very high level, I think the first principle is providing notice. So explaining how you're using data collected. 2, providing data subjects with choice before disclosing data to third-party recipients so that they can opt out of it. The third is accountability, and what this really translates to is making sure that if data is then transferred to a subsequent recipient or sub-processor, subcontractor, that recipient is subject to the same restrictions in place on the company. Fourth is security. This is, again, here would just be making sure that reasonable and appropriate measures are taken to protect the data from loss or misuse. There's principle on purpose limitation, basically just limiting how you use data to how you said you were going to use it. There's a set of consumer rights that would look very familiar to anyone who's worked on compliance with those state privacy laws. It means giving consumers the right to access their data, correct it, delete it. And then the last is just providing data subjects with a recourse or means of submitting a complaint if they find that the company is misusing the data or not adhering to any of these principles.
So Natalie, and maybe interested in your take on this, Julian, because so presumably to enact new law in the United States to set out the requirements for companies who want to participate in this and to limit how national security organizations may gain access to European data, we would need a law passed by Congress and signed by the president. Is that what happened here?
Oh, yeah, you're giving me like PTSD from all of the discussions that we've had on this over the last 2 years. So that is not what happened here. Rather than changing the approach to surveillance or maybe the authorizations that the intelligence community in the US has for going out and getting data through signals intelligence agent activities, the President Biden, issued an executive order. It's EO 14086, and it came out in October 2022 as a necessary element of the negotiations now that have concluded for the data privacy framework. So just taking a step back, we should consider that this was a 3-year process, and in fact, what a monumental task the governments in the EU and the US have achieved. Privacy Shield is invalidated. And then you start this 3-year process to negotiate a new agreement. Obviously, the Commission, I think, throughout the process wanted to reach an agreement, but they didn't want to put something forward that would get struck down for a third time. And as we know, everybody who follows the news in this area knows that there will be challenges even to the data privacy framework. So it was clear that some kind of change had to be made to the way the intelligence community or the authority of the intelligence community is able to access the personal data of European individuals when that data is transferred to the US. If you read the Schrems 2 decision, there's not much analysis of US law. It seems maybe like the court used the conclusions about US law made by the Irish High Court, who referred the decision to them. But I guess maybe at this point, that doesn't really matter as much as the fact that regardless if that was a right analysis or not, it was clear early on that some kind of change would have to be made. And so I think for a long time, kind of the commenters in Europe were saying that this would have to be a legislative solution. For example, the Foreign Intelligence Surveillance Act, right, that authorizes certain types of intelligence gathering activities and notably is the main authority that the Court of Justice complained about, is promulgated through an act of Congress. And, there are independence requirements that it was not clear that if the authority or if the new restrictions that we're relying on were promulgated in the executive branch, which is also the branch conducting surveillance activities, that there would be the independence required under European law between the restrictions or the safeguards and the actual authority to go get this data. And we can talk more about kind of how those issues have been solved, or at least the attempt to solve those issues. But it's true that one of the big challenges here was to determine whether executive action would be sufficient or whether this would have to go through a legislative process. I think all of our US watchers know that it can be difficult to move the ball through legislative process. So the finding in the end is that the executive action is sufficient for these purposes. And hopefully, eventually, if there's a challenge, the European Court will agree.
So Natalie, before we kind of get into the whether we should do it or not do it, but I want to just make sure that we understand what certification looks like, because we understand that this is a framework that, Julian, you just pointed out, that is by executive order. In other words, as I understand it, it doesn't apply automatically. And so if I'm an organization who is transferring data or receiving data in the United States, and I want to make that easier, it sounds like the data privacy framework is one of the solutions that I could consider. But what actually needs to happen in order for an organization to participate?
My view is that it's definitely worth, any organization's time that wants to be importing data into the US. I think the reality is that there are a few kind of types of companies that are impacted here, but the ones at the very top, I'm talking about size, will have these robust multinational privacy compliance programs. And if they haven't certified previously, they're in a good position to certify. But then there are also these smaller types of companies, maybe who aren't even multinational or are just getting into the multinational space and haven't kind of developed their compliance programs with an eye to what's going on outside of the States. And so would need to do some kind of compliance uplift to be able to self-certify with the DPF. Well, the DPF also is an attractive mechanism for those companies because it's such a streamlined way to get to that authorization to import European data versus potentially lengthy negotiations to enter into SECs with your foreign customers, or maybe developing your own SECs and paying a law firm to put those together. So I think the DPF is great and it provides a lot of advantages. And I think we're going to talk later about maybe overlapping that with other transfer mechanisms. But I'll just say, to actually self-certify or to become part of the DPF, there are a couple of classes of companies that we need to think about. One are the companies, and when the Privacy Shield went down, there were about 5,000 companies signed up for that mechanism. I haven't done the analysis, but I presume a lot of them have maintained their certification, even with the Privacy Shield, even when that program was offline and they couldn't actually use it. Well, those companies now are in a really good position to participate in the DPF. First of all, because the core principles that they need to comply with haven't changed much. So they should have those compliance measures in place. And second, because they're automatically being rolled over into the DPF. The Department of Commerce said very clearly, even before launching its website, which came out on July 17th, that active Privacy Shield participants would automatically become data privacy framework participants. And so for those companies, they don't need to do another initial self-certification. What they need to do is check when their annual recertification would have been, because that timeline is going to stay the same. They'll also have to update their notice materials. That's one of the big ones, right? Because as you outlined, Natalie, the Privacy Shield and now the DPF requires that companies publicly commit, as part of their self-certification, publicly commit to complying with the data privacy framework principles. And so that's a key action item, updating privacy notices. For these companies, they'll have this 3-month grace period to update their notice materials and to come into full compliance with the DPF. That has to be done by October 10th, 2023. The other big one that I've been looking at, so again, this is for companies that already had their Privacy Shield compliance mechanism in place, and so should have what's needed for the DPF. The other big piece I've been looking at is for the accountability principle. So pursuant to first the Privacy Shield and now the DPF accountability principle, companies have to be able to show that they have some kind of mechanism internally to verify compliance with the principles that they're self-certifying to. And this is really important. I feel like this is a practical tip, because even if you were recertifying while the Privacy Shield was offline and doing kind of a basic compliance review as part of that, you may not have been engaging in as robust of a review as you'd probably want to engage in now to make sure that you're complying. And so if you don't have a documented review of whether you're complying with the DPF principles, that's definitely something you want to get in order sooner rather than later, and definitely by October 10th. So those are for companies who maintain their Privacy Shield certification. And then there are other reasons. So if you change your certification compared to what you had from Privacy Shield, for example, you weren't transferring human resources data, but now you are, you need to go into the data privacy framework and update your certification and your processes to reflect that.
Really helpful context. I mean, there's a lot there that I think we could spend time kind of breaking down. But just some of the key things that I heard you say is, one, that participation in the framework is not automatic unless you were already certified to the Shield. In other words, you have to go through a self-certification process with the Department of Commerce. Two is that the participation in the framework has a lot of benefits for you to be able to then seamlessly transfer data from the EU to the United States without a lot of the friction that was created by the Schrems II decision. And then three, I think you were also pointing out that there is some uplift that would be needed in order for organizations to bring themselves into compliance with the framework and allow them to meet those substantive requirements. And maybe with that, Bret, I'm interested in your perspective as organizations consider whether to participate in the framework, perhaps for the first time, or perhaps they are Shield certified and they want to continue to participate now in the framework. How are you talking with clients about both what the substantive requirements look like and maybe perhaps what the risks are of participating? Because obviously these are new requirements. And so that means that there are ongoing obligations.
So, in terms of the substantive requirements, as Natalie pointed out earlier, this is not much different than Privacy Shield. And I would say for global organizations who have been trying to unlock the mystery of international data transfers over the course of the past 5 to 10 years, those having GDPR compliant processes in place, or as Natalie pointed out, complying with many of the U.S. state laws, you're probably going to be 90% of the way there, if not all the way there, right? Let's just say you're an average company and you've been using the standard contractual clauses since Schrems II, or even before that, for a number of your transfers. well, you're subject to a number of substantive obligations under those standard contractual clauses anyway. And assuming that you're complying with those standards, then you should be, relatively good under the standard, under the data privacy framework. So from a substantive perspective, it shouldn't be so difficult. And one of the things you can do, and one of the things we're developing, are sort of crosswalks in between existing privacy programs or existing frameworks and the new data privacy framework to enable you to understand whether or not you can certify, right? So that's step one in terms of the substantive requirements. In terms of the risks, the main additional risk posed by the data privacy framework is that you're subject to enforcement in the U.S. side by the Federal Trade Commission if you are not in compliance, or if you let your certification lapse, or if you don't do your annual recertification or verification assessment that's required under the principles. And I strongly suspect that the FTC will play its part and be motivated to investigate referrals from the European authorities if there are concerns that particular companies aren't complying with their obligations. So there's that extra sort of risk component because now you're subject to a separate regulator. But to the extent that you're a global company, you're handling data responsibly under a privacy program that's generally subject to GDPR and the U.S. state privacy laws, you should be confident that you can adapt that program to one that is compliant with the data privacy framework, and you can be subject to some of the benefits that we've talked about and can talk further about.
So, Bret, I want to maybe piggyback on that question around kind of the FTC's enforcement of this. So as I understand it, right, this is a Department of Commerce program that is enforced depending on your regulator by the FTC primarily, or Department of Transportation, but it's an area where you're holding yourself out as being certified and adherent to these principles. And then to the extent that you don't comply with those principles, or what under your commitments under the certification, that would be considered a Section 5 unfair or deceptive trade practice. That's the same framework that I think was also applicable within the Shield and the directive. What was enforcement like under those regimes, and how do you see that to be different or the same this time around?
Yeah, there was a lot of enforcement under Privacy Shield, although in most cases it looked like it was companies who just copied others' privacy policies and said, I'm compliant with the Privacy Shield when they had not actually certified. So it was sort of facially, not that they were actually non-compliant with their obligations. They just actually weren't certified, but had publicly represented that they had. But there were a few handful of enforcement actions where companies were found by the FTC to be in non-compliance with their obligations under Privacy Shield. And again, I do expect the FTC to be on the lookout for this, in part because of some of the criticism that has been coming from the European side about Privacy Shield and Safe Harbor. So, U.S. companies sign up and then there's no enforcement. And I think the Department of Commerce and the FTC have been very cognizant of that. Now, does that mean that U.S. companies should worry about signing up to this because there's going to be a focus on trying to signal to our European friends that we take this seriously in the U.S.? I don't think so, because in reality, the companies who are doing the right thing and who are undergoing their verification assessments, on a yearly basis like you're required to, and are otherwise keeping their certification up to date, aren't going to have serious issues under the new privacy framework.
It's really helpful, Bret. Maybe Natalie, I'd ask you for your perspective on this, but maybe kind of with a specific lens, because I think you had pointed out, right, that this is an embodiment of a number of principles that already exist. Bret is saying that, if you're already doing a lot of these things, this is not going to be a significant lift. It also comes at a time where, as all of us around this virtual table know, our clients are under a lot of stress to try to meet all of these new and expanding and almost on a daily basis changing privacy requirements that are coming at them in so many different directions. How do you see this development as to fit into the daily lives of all of those privacy professionals who are reacting to all of these many developments to protect their organization from data-related compliance and data-related risks?
It's a good question and completely agree. I'm sure the privacy professionals that are clients, their heads are probably spinning with all of the latest developments in the space. But I think this is one of those developments that actually should ease the burden on them, in the sense that, as we discussed before, transfers of Europeans' data to the US used to have to be pursuant to a specific type of contract or a specific addendum to contracts. So that operationally required companies to add these addendums to first identify which contracts governed data being transferred from EU to the US, and then to make sure they added these specific provisions. And that might sound like it's not operationally challenging, but in practice, especially when dealing with counterparties that are not very sophisticated in privacy matters, could lead to a lot of back and forth and a lot of privacy education. Whereas the data privacy framework kind of avoids all that by allowing companies to go through the procedures that Julian and you, Scott, summarized, and relying on the framework for all transfers going forward.
So net benefit, right? In other words, if I'm hearing what you're saying correctly, and what Bret has made the point about, is that this is not all that different than what many of our clients who are embracing and meeting the requirements under all of these developing laws, that if you're doing all of those things, this actually is a net benefit, because we're taking out some of the friction that was created when the shield was invalidated.
Yes, it should alleviate the burden of entering into these new relationships that involve cross-border transfers of data.
So, Julian, my last questions is for you. You were describing a moment ago about the things that companies should take to be able to kind of meet the new requirements under the framework. I think the two examples you had provided, one was updating your notices and then building out your accountability backend documentation. Can you say a word about how companies should be thinking about the framework, in addition to the things that require them to do it now, but in light of the uncertainty about how long the framework will continue to persist? Any kind of thoughts about how companies can say, hey, I'm ready to embrace the framework, but I've been down this path at least twice before where I've relied on it and then it was invalidated. How are you thinking through that set of questions?
Sure. Thanks, Scott. I mean, the first thing I'll say is we got 4 years out of the last one. If you're a global company and you're dealing with the laws, you're dealing with emerging laws all over the globe, you're probably going to review your data transfers procedures within the next few years anyway. I do believe that this is more resilient than the Privacy Shield. There have been changes to, the fundamental issues that the Court of Justice highlighted through the executive order, and the European Commission's findings are much more thorough than they were under the Privacy Shield adequacy decision. So I think that's an important piece not to lose sight of. I think the main consideration in answering the question you asked is for companies that are transferring data or are transferring EU personal data, and have been all along, when the Privacy Shield went down, if they weren't using standard contractual clauses, that probably was the appropriate safeguard that they pivoted to. And there they probably spent a lot of time developing their template contracts, determining which supplementary measures they could implement, and renegotiating agreements with vendors and customers and all third parties. And documenting their transfer impact assessment, right, which is the document that companies are required to adopt when using standard contractual clauses to assess the risk coming from the transfers. So they did all that work for the SECs. My sense is that they can keep their SECs and they can use the data privacy framework as a stopgap measure. I think it would be challenging to abandon the SECs that you've developed and just go to the DPF. I think these two mechanisms can be used in tandem. Two challenges I wanted to highlight with regards to that is, one is I do think you need to be clear about which mechanism you're using or at least you need to have a sense of it. You can't just say, well, these transfers are either under the DPF or under the SECs, because remember that the SECs are enforced by European regulators. And so you could have that kind of language, that stopgap language, and then be satisfied that your transfers are under the DPF and are not directly reviewable by a European regulator. But the European regulator could always say, well, wait, these transfers are actually done by the SECs. You have contract language supporting that. And so, we want to ask you some questions. So I think you can use these together. The belt and suspenders approach is the way folks refer to it, either in tandem or overlapping. But I do think you need to have a strong sense of the mechanism that you're using as part of a particular relationship and as part of transfers. The principles or the core obligations you'll need to, either under the SECs or under the DPF, that you'll need to adhere to are similar, but the enforcement mechanisms are different, and there are some kind of procedural nuances to consider if you do that.
I just want to follow on really quickly. There are a few other good reasons to do the data privacy framework, notwithstanding the inevitable challenges to it. The first is the belts and suspenders approach that Julian was talking about. There are challenges currently to the standard contractual clauses, right? So if those are invalidated, you'll have the data privacy framework in place and we'll play the game all over again. Another reason is for some types of companies, the data privacy framework is inherently more useful. Let's say you're a US based processor or service provider that's doing lots of work with lots of different customers, and you can access the standard contractual clauses from your DPAs, and you say, hey, we're subject to the DPF, and that covers everything. That simplifies the contracting process somewhat. Again, don't know if you want to do that entirely because having the belts and suspenders approach, but that's another thought. There are a number of provisions in the standard contractual clauses that are super onerous also, such as the provisions related to challenging law enforcement requests that you have to provide, you undertake best efforts to push back on every single request for information, and other sort of obligations under the standard contractual clauses where the DPF may ultimately prove, substantively more favorable to you. And then, I would say, as Julian said, picking your regulator. Although that line has blurred with the extraterritorial reach of GDPR, you might prefer to be regulated by the folks at home rather than subjecting yourself to every decision by the European DPAs.
That's a great conclusion. I think I'm going to ask one final question in a rapid fire format for each of you. And I'm going to ask you to step out of your role as being a prominent data protection lawyer at Hogan Lovells and instead envision yourself as being the chief privacy officer at a multinational company, including one that's operating within the EU. And now you have one of your tools is potentially to participate in the data privacy framework. You have been struggling with or been working with embracing and adopting all of the various laws that are coming online, both in the United States, trying to comply with the GDPR, and your boss comes to you and say, should I participate in the framework? You have three options. A, embrace. B, be cautious. C, heck no. Bret, which one of those do you go with?
I'm going to say embrace generally because of the sort of helpfulness of having multiple measures in place. I do think it's also a good signal to the market that you take this seriously, that you're putting some skin in the game by subjecting yourself to additional enforcement. There may be some, let me say, it's more useful for mass transfers, or let's say, I'm like I said, I'm a US based data processor that accepts lots and lots of data. But if I have one set of data transfers that's internal to my company, maybe it's of employee data, maybe I just sign the standard contractual clauses and be done with it, right? But for the larger types of regular transfers from third parties, I'm going to embrace it.
All right, Natalie, for you, embrace, caution, or heck no?
I'm going to go with embrace, which doesn't make for an exciting podcast, but is true. For the reasons Bret said, I think the benefits of data privacy framework for the lives of transactional attorneys on my team, as well as the privacy attorneys, it really outweighs the administrative burden of either rephrasing my Privacy Shield framework or signing on to this one.
All right, Julian, I'm going to give you the last word. Are you going to disagree with the group or are you going to follow suit?
No, I mean, I would say embrace, but I would set the meeting in a couple of days so I can get talking points from my outside counsel.
All right, that's a great place to end. Really appreciate all of the panelists' time and participation in this podcast. My gratitude to each of you. And thank you, everybody, for the audience for tuning in and participating in this conversation. Looking forward to the next one. Bye-bye.
Thanks, Scott.
Thanks.